on community integration of people with disabilities, which is sort of a substantive topic of this first briefing, following kind of the history and vision of ADA. And as Kai said, the whole point of the ADA is really to erase the line between us and them, and to the more that you have people with disabilities integrated into the workforce, into all aspects of society, the more that you can break down barriers and stereotypes and prejudices and actually more fully integrate people so that they can participate and live just like people without disabilities. So this panel is a tremendous panel. It brings a wealth of experience on community integration issues. We're going to start with Clyde Terry. Clyde is a member of the National Council on Disability. I think Kai or Arlene Kai alluded to the National Council in her talk earlier. It's an independent federal agency charged with advising the President, Congress, and federal agencies about policies that affect people with disabilities. The Council has 15 presidentially appointed members. Clyde is one of those, and Clyde is the chair of the Council's Committee on Policy Development. Clyde is also the CEO of Granite State Independent Living in Concord, New Hampshire, and was previously the executive director of the New Hampshire Developmental Disabilities Council. And Clyde is going to talk about a little bit of background on the ADA's integration mandate and why it is important to people with disabilities. Eve Hill, or actually, no, I'm going to move from Clyde to Beatrice Bacon. Beatrice is a resident of Adams, Oregon. She previously lived in a Washington area nursing home and was a plaintiff in a lawsuit brought by University Legal Services to obtain community housing and services for people with disabilities who lived in several DC area nursing homes. And Ms. Bacon now lives independently in her own apartment, where she is very happy to be. She'll tell you her story of what the integration mandate has meant for her personally. She has experienced the integration mandate, I guess you would say, firsthand. Then Eve Hill, who you all don't realize this, but Eve actually stepped off a plane after a 14-hour flight from Japan to be here with us today at this briefing. Eve is Deputy Assistant Attorney General for Civil Rights at the Justice Department, responsible for the Civil Rights Division's disability-related work. Eve has long been a leader in the disability rights community, and actually I think if I went on about all the places that Eve worked, I would probably be here all day, so I will just name a few, including the law firm of Brown, Goldstein, and Levy. Before that, she was a senior vice president of the Burke Blatt Institute at Syracuse University, the first director of the District of Columbia's Office of Disability Rights, and executive director of the Disability Rights Legal Center in Los Angeles. And Eve is going to talk to us a little about the Justice Department's enforcement of the ADA's integration mandate. And then Ira Burnham, my boss, the legal director of the Bazelon Center for Mental Health Law in DC. Bazelon Center is a national nonprofit legal organization that does policy advocacy as well as litigation to promote equal opportunities for people with mental disabilities in all aspects of society. And IRA's main focus is community integration of people with disabilities, and he and the Bazelon Center played a leading role in the Olmstead case in the Supreme Court, and he has been involved in litigation across the country to promote community integration and works with federal agencies as well to develop policies that promote integration. And Ira is going to talk about sort of the vision of the integration mandate, the principles that have been embraced by the disability community around what community integration means. And then finally, Professor Sam Bagenstos teaches at University of Michigan Law School, specializing in civil rights law and public law and litigation. From 2009 to 2011, Sam was the Principal Deputy Assistant Attorney General for Civil Rights and number 2 person in the Civil Rights Division at the Justice Department. And among the many things that he did at the Justice Department were the promulgation of the first comprehensive update of ADA regulations since 1991. In 2010, there's a very large set of ADA regulations that finally were issued under SAM's supervision, and really, I think most importantly, the reinvigoration of the Justice Department's enforcement of the ADA's integration mandate and the Olmstead decision. And SAM's advocacy or SAM's work in this area has really, I think, brought tremendous changes across the country, and it was very interesting to see that the Justice Department's work really started transforming state service systems when SAM came. And SAM led the negotiations of significant Olmstead settlements with the state of Delaware and the state of Georgia, and those became, I think, model Olmstead settlements that have defined the direction in which the administration has been going. Sam is going to talk a little bit about the future of the ADA integration mandate, where we've been and where we're going, and also specifically say a few things about the relationship of the integration mandate to Medicaid. So let us start with Clyde. Whatever you want, I think that's the easiest. If people want to go here, they can. If people want to stay there, they can.
That's not it?
No.
Oh, okay. Are we on? Okay. Good afternoon. A little bit of a reasonable accommodation for me since I can't see you. Could folks who are staff or the senators, would you mind clapping real quickly? Okay, that helps. And for folks who are advocates and members of this great community, could you clap? Thank you very much. That sort of gives us about a 60-40 split. At least now we all know who's in the room. Thank you. Yes, I guess my charge this afternoon really quickly is to give you a 30,000-foot view of exactly the integration mandate and the Olmstead decision. And I'll let the many fine experts on this panel, dig down a little bit deeper and talk in terms of some of its implications. Before I get there, however, it's really important to sort of take a quick look back as to how our cultures, and ultimately ours, have responded to the needs of persons with significant disabilities, whether they're intellectual disabilities or developmental disabilities. And in time, perhaps many centuries ago, or maybe not all that long ago, children that were born with significant disabilities were often left by the roadside in baskets, for families felt that they had no value, they couldn't work on the farm, they realized that they would be some kind of burden, and they were essentially left to die in sunshine. Over time, our culture has evolved and matured, and we felt it really was pertinent that perhaps maybe it would be best, since families really were not equipped, or the medical community felt families were not equipped, that the best thing to do for children with significant disabilities was to send them to that place on the hill with fine brick architecture and growing vines, often with soothing architecture. It was indeed the best thinking at the time that perhaps that would be the best place with folks with significant disabilities. But what we have learned in time is that simply warehousing people did not promote the best of who we were as a society, but that at some degree promoted the worst of who we are. Because if we put people away somewhere else where they're out of sight and out of mind, it leads us that they are forgotten, that they're less than equal, that they're less than human. And often as budgets got tighter and staff became fewer, the worst fears of many of those individuals came true. Left to be warehoused, left to be unclothed, left to be showered by fire hoses, abused by staff, and really it was not our best days in sort of the American history as to how we dealt with folks with significant disabilities. Prior to the ADA, the way in some cases lawsuits were brought to try to remedy this situation and to ultimately just, as a final edict, close these places on the hill, if you will. Folks were, the goal was to shut the doors and turn people out into the community and often into the streets. Our failure was that we never built a support system, a structure that could allow those folks to mature and grow and really be an asset to our society. So along came the ADA, after the great work of some of the people on this panel and many of the folks who have passed away since then. And within the ADA was Title II, the provision that really compels state and local governments to comply with the basically non-discrimination provisions of the ADA, that no state service and program may discriminate against a person with a disability simply because they had a disability. It didn't mean that a state or local government couldn't have a separate program. It merely meant that if the individuals wanted to participate in the rest of the services and programs of state government, then they certainly had a right to do that if they chose to. So we get to Olmstead really quickly. I'm trying to give you the fast version here so we can get along to the important part of the discussion. And in the Olmstead discussion, we had a situation in the state of Georgia where we had two young women who were in an institution. They benefited from the treatment there, but the time was one and they chose that they wanted to return home to their town, to their community. And the state of Georgia essentially said no, because there was no service system available to them. Through the litigation and the Supreme Court ruled, because of the integration mandate, that these individuals did indeed have a right to live in the community, basically because of Title II of the ADA. The fascinating thing about the court's decision is twofold. And it's really the first one is fascinating. For what the court essentially said is, by having a structure, a conscious decision by states that put people in institutions, we perpetuated the attitudes that people with disabilities could not live independently, that people with disabilities could not work, that people with disabilities were somehow devalued, that they could not be full members of our community. And then the second part of the decision essentially said that by isolating people in such institutions, we're denying them their rights to participate in the community, to be active involvement, to share time with family, friends, employment, vote, my favorite subject. All these things were essentially all aspects of community integration that the court said were fundamental, that were rights under the ADA, that the Olmstead decision essentially affirmed that they had a right to exercise. In the end, for the disability community, particularly you folks who are new to this community today, what this decision is, it really is sort of the Brown versus Board of Education decision for the disability community. It affirms that separate is not equal, and rather folks with disabilities had a right, equal treatment under the law. So where are we today since the 14 years since the court ruled on Olmstead? Many things have occurred, and this administration in 2009 ushered in an executive order of the year for community living, right? The community living, which really encouraged federal agencies to work together to promote community integration for folks with disabilities so that they can indeed live with families, friends, and take advantage of community activities that existed. The administration's passage of the Affordable Care Act had many provisions in it to encourage the structure of community-based service systems for folks with disabilities and others so that they would get the support they need once they were no longer in an institution. Many sort of innovative grant ideas, as well as the prohibition against being denied health insurance on the basis of simply having a disability. The Health and Human Services, they reorganized the administration on community living, combining a number of federal agencies under one umbrella to indeed enhance and promote the same agenda. For the National Council on Disability, we have repeatedly produced several reports. They're on our website about sort of the progress and the need for more resources to promote community living for people with disabilities, our report card on deinstitutionalization, and just last fall we issued a toolkit for state and local governments as to how they can increase their community deinstitutionalization activities. Also, a year ago, the Council issued a report on the subminimum wage provisions 14C, which are essentially segregated work or sheltered work sites to encourage community supportive employment, integrated employment for individuals with significant disabilities, so that indeed America cannot afford to waste the skills, talents of anyone, and we need to find an aspect of folks with disabilities to be fully employed just like everyone else. At the end of the day, the Olmstead decision in Title II is not about those people on the Hill or those people across town. It really is truly about all of us. It's because the incidence of disability are on the rise in this country as we all start to age, and we all want to be valued and be considered full-fledged citizens. So whether it's for yourself, or someone you love, another family member, or merely a friend, or even someone you don't know today, the ADA is to protect all of us, to enhance all of our abilities, so that we all can be the best that we choose to be. Thank you.
Good afternoon. My name is Beatrice Duncan. I would like to tell you about what the Americans with Disabilities Act has meant for my life. Because of the ADA, I was able to escape from a life that was stifling and confining in a nursing home where I didn't need to be. I was able to move to my own home where I could live like an ordinary person and make my own decisions. I am 49 years old and I have 3 children, ages 24, 27, and 29. For 2 years I lived in Washington Nursing Facility in Southeast Washington. I was sent there because of my disabilities. The only choices my case manager offered me were a nursing facility or a homeless shelter. I am partially paralyzed and use a wheelchair to get around because of a childhood car accident, and I also have bipolar disorder. Living in a nursing home was one of the worst experiences of my life. I lost all control over even the smallest aspects of life. In the nursing home, they decide when you go to bed, when you can eat, what you can eat, and who shares your room. There is always a lot of noise and chaos with people yelling. Sometimes there were fire drills at 2 or 3 in the morning. There is no privacy in the nursing home. You have to live with a roommate you didn't choose, with just a curtain between you. There's no place to have privacy with visitors. There are always other people overhearing your conversation. There is also no privacy with phone calls. At first, residents had to take their phone calls at the front desk. People could overhear doctors and nurses talk about other residents. Then they said we had to use the payphone in the public area, and most residents had to have their own phone conversations there. I was lucky enough to have my own phone installed in my room because my mother put it in, but even there I had no privacy. In the nursing home, you lose your dignity. The staff don't knock before they come into your room. They simply barge in at any time. You can't lock your own door. Staff also weighs you constantly, and if they think you weigh too much, they put you on a diet and they decide for you what you will eat. While people with disabilities may need some help, we don't need to be treated like children. But nursing homes and other institutions are designed to control every aspect, almost everything about your life. It is often hard to get any personal attention in a nursing home. One time I had tremendous pain, and I kept telling staff all night that I was in great pain all night. They ignored me until morning when it was more convenient for them. It turned out that I need to have my gallbladder removed. The doctor said I could not have waited much longer. I also had trouble getting around outside because no one would help me. One time I wanted to see my son. who is a musician performer. The nursing home staff kept promising me that I could go to one of his shows. But when the time came, I had to miss the show. I would have had to be escorted by someone from the nursing home, but no one from the home was willing to buy an extra ticket in order to escort me. I had no idea that this is what life would be like when I came to the nursing home. For most people, no one comes to see them once they move into the nursing home. People don't want to come because it's depressing and it smells. There were many people in my nursing home who just wanted to die. I became one of the plaintiffs in a lawsuit under the ADA seeking opportunities for nursing home residents to live in their own homes. After I sued, I was finally offered the chance to live in my own apartment with the services and supports I need. Moving into my own place was one of the best things that ever happened to me. Now I have freedom. I can make my own decisions and choices. No one makes decisions for me. I no longer feel isolated. At the end of the day, no matter what happens, I have peace of mind knowing I can come back to my own apartment. I can spend time that I want with my family. This July 4th, I hosted my family and grilled food for them, and then went to see my son perform at the Kennedy Center. It was fantastic to be able to do that. I could not do things like that when I was in the nursing home. I am so grateful that I have been given a chance to live independently. There are still too many people with disabilities who have not been given the opportunity, though. Every time I see people going into the nursing home where I used to live, I think, God help you. I hope they can too have the opportunity to receive community housing and services and live a full life one day. I feel like when you have a disability, people treat you like it's a strike against you. It shouldn't be. I would like to work in human rights so other people don't have to go through everything I've gone through. However, one thing I still have not had the opportunity to do is to work again. Instead of a day program, I hope that one day I will have the opportunity to get employment services in order to maximize my independence. Overall, I am extremely grateful for the ADA because the ADA, I have a lease that says beef is vacant and a place that belongs to me. No one can take that away. Thank you very much.
But we know that many people with disabilities face a tyranny of low or no expectations, and that cuts off opportunities to live, work, play, and contribute to their communities alongside everyone else. That tyranny of low expectation is something we see at the Civil Rights Division every day, in the assumptions that are often written into the laws that all people with disabilities can't participate in the world, in the special programs that are described as opportunities to participate or prepare for participation, but that become permanent, segregated institutions. And in the barriers that stand in the way of allowing people to maximize their contribution to society. And we're working to change those expectations, open up folks' participation, and break down those barriers. As in the U.S., as Clyde mentioned, as in many countries, our tradition was to take children and adults with disabilities away from their families and their communities and put them together in segregated settings for treatment. And the Department of Justice's role in enforcing the ADA and all the federal civil rights laws is to take on systemic cases, statewide systems where that has happened. In particular, under the integration mandate, we take on statewide systems that over-rely on institutions without providing individual community supports. And we sometimes take statements of interest in private litigation, intervene in private litigation, as well as taking on our own cases. Since our history of automatically placing people with disabilities in institutions, things have changed. Public funding mechanisms for our health systems have made institutions very expensive. Decreases in transportation costs and increases in transportation speed have made it more practical and inexpensive and possible to serve people wherever they are. Improvements in education have made it possible to teach kids with and without disabilities together and the same things, to prepare them for the world in the same way. And improved health care and understanding of disability have made it possible to treat people with disabilities in the community. And abuses, financial, physical, and emotional, have been exposed in institutions, demonstrating that segregation does not ensure either safety or cost effectiveness. And people with disabilities have grown to expect to participate in every aspect of community life, including having a job and joining the gym and meeting with their neighbors, right alongside people without disabilities. No longer is the choice for people with disabilities between institutional services or no services. It's between institutional services and high-quality, integrated, individualized services in their communities. And fundamentally, I think in part because of the ADA and our other civil rights laws, we as a community have stopped seeing people with disabilities as fundamentally different from people without disabilities and recognized in a real way that separate is not equal and is not necessary and is not acceptable. So under the integration mandate since 1999, states have been required to serve people in the most integrated setting that's appropriate for them. The court found that unnecessary segregation of people with disabilities is discrimination in violation of the ADA. And the court found that segregation in itself is harmful because it continues and validates incorrect assumptions that people with disabilities are unworthy of or incapable of participating in their community. And then also that it prevents them from enjoying the benefits of being in their communities, things most of us take for granted. So our first case at DOJ, focusing strictly on the integration mandate, was in Georgia. Ironic, because Georgia was the site of the Olmstead case, and yet 10 years later was still relying on institutional systems. So that agreement calls for community-based services for over 10,000 people with disabilities, with intellectual disabilities, developmental disabilities, and mental illnesses. We've also reached agreements with Delaware to help 3,000 people with mental illness leave psychiatric hospitals and enter the community. In Virginia, for 5,000 people with intellectual and developmental disabilities at training centers. North Carolina, for 3,000 people with mental illness in adult homes. And just last week, with New York, for 2,000 to 4,000 people with mental illness in adult care homes. We also have active litigation going on right now with New Hampshire regarding people with mental illness kept in psychiatric hospital and a nursing home. So our cases have challenged over-reliance on state-run institutions like psychiatric hospitals, nursing homes, and DD facilities, and on privately run but state-funded facilities like nursing homes and adult homes. We've challenged institutionalization of people with mental illness, intellectual and developmental disabilities, and physical disabilities. We've asserted the rights of people already in institutions and of those who are at serious risk of entering institutions. There's no reason you should have to go into an institution in order to get services in the community. And we fought for the rights of adults, and even just last week we filed a suit on behalf of approximately 200 children in Florida unnecessarily placed in nursing homes. Children in nursing homes today. We've challenged unnecessary institutionalization not only in where people live, but now also in where they spend their days. In June, we reached an interim agreement with Rhode Island and the City of Providence to provide integrated, supported employment services and school transition services to 200 adults and children with intellectual and developmental disabilities who were in segregated sheltered workshops in the adult system and in a high school. And we continue our litigation with Oregon regarding that state's over-reliance on sheltered workshops for people with intellectual and developmental disabilities. Because segregation is so prevalent in so many aspects of people's lives, Olmstead implementation is not just limited to the Department of Justice, I'm happy to say. We've worked closely with HUD, HHS, Labor, and a number of other federal agencies to ensure that the puzzle pieces of integrated lives can be addressed and incorporated in all aspects of what the federal government is doing. So, but someone just last week accused me of being ideological. Why? That too. That's hardly ever shaped as an accusation. But why has Olmstead enforcement been a priority of the division? Well, first, many of the ADA's rights to equal opportunity and reasonable modification will be meaningless if people with disabilities can't get into the community and access them. What is your right to go to a restaurant without discrimination if you're not allowed to leave your nursing home to go to the restaurant? Also, we already know that separate is not equal. It's not equal in this context either. And how will people with disabilities ever be able to contribute to their communities? And we need everybody's contribution if we keep them locked away. And then as Kai and Arlene talked about this morning, how will people without disabilities ever learn that people with disabilities are equal, worthy, valuable, if they don't get to interact with them? How will the stigma, the prejudice, the incorrect assumptions ever go away if anyone can still say, oh, I don't know any people with disabilities, because don't they take the special bus and live in the house on the hill? But this isn't about ideology. We now have a website called Faces of Olmstead that shows the real reasons this is a priority. Some of the people whose lives have been changed for the better because of community-based services now available to let them leave or stay out of institutions. And I want to talk about a few of those people. Doug in Virginia lived at a training center for people with IBD for 20 years. When he left, he used a wheelchair and he had to eat all his food in pureed form. Now he lives in a small group home near his family, and he walks and he eats hamburgers and cookies, his favorite foods, without putting them through a blender. And as his father says, he is happier and more active than I ever imagined was possible. Rose in Delaware was formerly homeless and placed in a psychiatric hospital for 2.5 years. Now she lives independently with supports. She says the Olmstead Agreement in Delaware gave her life back. Now she feels safe and can, quote, can have neighbors and friends in the community, and she's even helping to organize a women's wellness group in her community. And Stephen in Rhode Island, who I met just a few weeks ago, is another example. When he entered a sheltered workshop, after working in a hardware store in the community, he thought he'd be there just for a little short time. 30 years later, he's been asking for help to find a job in the community every time he had the chance. But his requests were ignored because the state's funding system supported sheltered workshops and not supported employment. This year, as a result of our settlement agreement, he's finally being helped to find a job in the community where he'll have what he says is the opportunity to be with different people, to talk to different people, and to feel independent. Now, is that too much to ask for 30 years? And in one of the earlier cases, the state of Missouri tried to deny Nina the supplies she needed unless she would go to a nursing home to get them. She had broken her neck and her back in a car accident, but she took the state to court and she won. And she says, Olmstead opened up a world for people like me who were trapped. I am 51 years old and I don't trap well. I hunt, I fish, and I've taught both of my granddaughters. Everything my parents and my grandparents did with me, I do with them. I consider it very important. It helps build strong family values. And that is something I could not do from a nursing home. So talk about contributing to your community and to your family and to the future of our country. That's why we do this. It's not ideology. is people, it's the whole country, it's the whole world. Thank you.